Lawyers of Reddit, what is the sleaziest thing you've seen another lawyer try to slip into a document/contract? I was told something really amusing recently. My client has directed me to is basically lawyer code for this dude pays my bills and I don't agree with him, but I have to make a good faith effort to get my paycheck. So please, judge and opposing counsel, please don't believe I'm stupid enough to think this will work. I see my client has directed me to a lot. I got sucked into a dispute with a former employer once over intellectual property rights in an employment agreement. They kept trying to sneak in a clause into the agreement in every other paragraph that gave them ownership of, full rights/responsibilities for, and access to anything I did remotely related to programming or computers outside of work while not on the clock. It was so broad, even my non-lawyer ass knew it was an awful thing. It became a deadlock argument back and forth until I asked if they were accepting liability for any illegal activities I could perform outside of work. Suffice to say those clauses disappeared by code the next day in the agreement. A law firm in which I worked helped out with a probate. The father, deceased, had 2 adult children who had testified that, yes, the most recent will had not included the half his aged girlfriend of the past month. The attorney for the gold digger sent a letter to the children which said, in essence, if you reconsider your testimony I'll fly you out, pay for your stay, and pay you $7,000 to change your testimony. The first person to reconsider gets double, but only the first. If you don't change your testimony, I will come after you with every resource an attorney has to make your life miserable. It's the sleaziest thing I've ever seen. Plus it put the firm in a tough position. Report him to the bar while the case was still ongoing. It would look like you were trying to influence the case. Report him after, and it looks like you're being petty and vengeful. Edit. People are asking what ended up happening. The kids changed their testimony, though it's not clear they actually got money for it or not. I'm thinking they did. So the gold digger got the money instead of the charity it had originally been meant to go to. The attorneys in the office where I worked called the sleazer bag and asked what's up with this letter. He immediately sent out a second letter which said I did not mean to indicate I would pay for your testimony, nor did I threaten. It's your fault if you thought I said those things. Both letters were sent to the Bar Association, and I don't know if anything has happened since. I once sent a contract adverse counsel for their client's signature. We had negotiated the final contract. This guy was a real sleazeball. He changed the contract to include a favorable provision for his client, had his client sign, and then sent back to us for counter signature. I don't remember how we caught it, but that is borderline malpractice right there. I get a lot of clients where the consultation goes something like this: client, can I do X? Me, no, X is illegal, and therefore you can't do X. Client, okay, I will do X anyway, even without your help. Me, okay, but now that I know you plan to do X, I can no longer represent you because I cannot assist in illegal behavior. Client, can we pretend we never had this conversation? Me, no, we can't pretend we never had this conversation. I get a lot of those. I'm guessing they then go to another lawyer that they lie to. In one case that I worked on, a company had donated a bunch of money to various things in a small town that they were polluting, and the documents always had a clause basically saying, and you can never sue us for anything. The people accepting the contracts just thought it meant anything related to this donation, or whatever. But nope. Most of the time other lawyers don't really try to slip sleazy stuff into documents, etc. But there are some lawyers who will try to do really sleazy things in other ways. It's really rare, however. This is primarily because your reputation in the legal community counts for a lot, contrary to popular perception. We settle most cases. As a result, trust matters. Example, I'm a plaintiff's lawyer. If I pretend that every case I have is a $1 million case, make stuff up, pound the table, manipulate witnesses, documents, etc., it will eventually become well known. The problem there is that when I really do have a $1 million case, every defense lawyer in town will know that I have a reputation as a consummate bullshitter who can't be trusted. Believe it or not, I actually settled a case for $1 million yesterday. It was a class action, and it was legitimately worth that amount. but I have a lot of other cases that are not worth that much money, and I won't pretend that they are. If we, my firm, had a reputation as a bunch of lying scumbags, we would have never been able to secure that settlement. Not a lawyer, but a habitual defendant. During deposition, lawyers always tell you to go slow, and when handed something to read, never assume it is what the cover page indicates it is. Page through and read the entire thing. I was being deposed in a business dispute and was handed a multi-page document. From the first page it was clear that it was a document that I was very familiar with that was about 20 pages long. I slowly paged through the first few pages, and it was the document I expected. I was about ready to set it down and say ready when my attorney said, "Did you read the whole thing?" So I went ahead and continued through the document. And what do you know? In addition to the full document, the other attorney had stapled some other important but disputed emails. Once I saw this, a little sidebar went down off the record. Of course their attorney claimed it was an honest mistake, but coming from an attorney, I don't quite believe that. I'm not a lawyer, but when my parents got divorced, it was messy. Real messy. And it dragged on for 3 years. Finally my dad got his day in court, but almost had to reschedule because my mom owed her lawyer $2,000 and he was threatening to quit on the spot unless she paid him right then. My dad agreed to pay the lawyer for her as long as it was in the settlement, so they quickly made a new settlement. Something that was also changed was my mom was supposed to get half the money from the sale of their house, about $100,000. Well, I guess her lawyer was pissed at her because in the settlement it never specified when my dad had to sell the house, and he got to keep the house until he sold it. So he could have kept the house forever after she had signed all the paperwork, then actually read the settlement. She was pretty pissed. My dad ended up selling the house for way cheaper than it was worth several years later. Haven't seen any of my lawyer colleagues try anything sleazy. What I have seen are some really sleazy conduct from their clients though. Example, man up for child abuse charges and wife abuse. He has physically and mentally abused his son from age 3 until age 16 when this case was brought to court due to an attempted suicide by his sister. Also a party in the case. Defendant, father, has over several years forced his son to attend a psychologist for various reasons, some which were relevant to the beatings the son received. During the trial, the defendant produces a signed document from said child psychologist where she and a colleague of hers both assign the blame of the abuse onto the son. The father has managed to convince 2 psychologists specialized in child psychology that somehow the child is at fault for being beaten. This caused quite an uproar in both the courtroom, which happened to be visited by a court reporter, not a commonality in Sweden, who went and wrote a long article about this case he had witnessed, and also in the psychology department. I wasn't a lawyer when this case was presented. I was a plaintiff in the case. It had an immense impact on why I later became a lawyer, even though I rarely work criminal cases these days. Contract theory is based on a notion of bilateral agreement to terms. Lawyers know this, and so they tend not to sleaze up contracts, because they know how many ways there are to argue against unfair or deceptive provisions. Corporate entities, however, rely on people not being lawyers, so they write sleazy contracts and rely on the money they make from 9 people not challenging unfair provisions to offset the minor court costs of the 10th guy who brings a suit. So, as a regular person, I managed to sneak something into my current apartment lease. If I signed before a certain date, I forgot. Rent was like $50 a month cheaper, or $500 over the course of the 10-month lease. When I failed to sign the cheap one, they sent me a more expensive one. I signed the cheap one and sent it in with my first month/deposit, and the lady at the desk accepted it, and I saved $500 because, and I suspect this is true with all corporate rental companies in my town, they don't actually check to see if it is the same document. Scummiest thing I ever saw another lawyer do. The company I work for was planning on leasing a fairly large parcel of undeveloped property. I was involved with the lease negotiations from the beginning, and they were taking quite a while. Basically, there were constant revisions to the proposed lease. Finally, after about 8 months of negotiation, we appear to have an agreement. I send over a copy of the lease to the other company's attorney for final review, and their client's signature if acceptable. They send a signed copy back about a day later, indicating that the contract is acceptable. I do a final review before I send it up to the executive to sign, since he didn't actually read these contracts. He just signed them after reading our summaries, and I noticed that there have been small but significant changes to the contract, all in the other company's favor. Unlike all of the prior revisions, which had been clearly marked, this guy just made changes without notifying us. My intellectual property law professor told us his story, where a company had a guy draw some blueprints, fired him, then changed the dates to make it seem like they had the prior art high ground. My professor and his partner tracked the guy down. He was in a dance band somewhere in the Midwest, and clicked to him. He said that he was so proud of the blueprints he drafted that he sent copies home to his mother with the original dates. The original documents were presented in court, which proved they altered the dates and the company paid out the ass. I'm not a lawyer, but an employment contract I was asked to sign had many pages and many places to sign. A couple of them had to do with giving the company I was applying to rights to my image and likeness. I just carefully removed those pages and returned the rest. I don't think they noticed, and I was hired. Another company that I applied to sold tobacco and tobacco products, and they wanted the right to take out a life insurance policy on me, naming themselves as beneficiary. I walked away from that one. We just had a real estate contract where we had verbally agreed to a price and conditions. When the buyer's agent sent the contract through, it was for $2,000 less than our agreed upon price, and had several rather unnecessary repairs that would have cost us several $1,000s to finish. Had we signed it without reading closely, we would have been obligated to perform those things that we had never initially agreed to. On top of it all, the buyer is trying to back out of the contract now, even after she signed it. It's all very frustrating. I've been an attorney since June 2013, and I already have advice for newer attorneys that I had to learn on my own. Chatty attorneys are dangerous. Here's how. You are ready for a hearing or other court appearance, and as per the norm, something they do not teach in law school, you are waiting for 45 minutes for the judge to show up. This is before the judge even calls the calendar, which involves waiting another half hour, unless you're lucky enough to be high on the list. The opposing counsel notices you and makes small talk. Be careful. Yes, it is true, many attorneys are friends outside of work, even if they are adversaries in the courtroom. I've seen it and have some friends. However, be careful. Small talk will turn towards the case you are both appearing on, and they'll say something like, "Man, this case is something else, right? If only there was a sign," or something similar. How I was burned. I can't remember what was asked or said during the small talk, which I assumed, my bad, was just banter while waiting for the judge. But once he arrived and we were called, the opposing counsel used what I said to prove his point without context. When the judge asked if I said that, I did, but had to add that he left out context, and the judge didn't care. Hearing lost. Ever since then, as soon as an opposing counsel gets chatty, I shut down with answers or go play on my phone like I got an email. Be careful.